Okay, welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the very basics of property law. We consider four fundamental questions in this series, and today we are focused on the third big question, and that is using property. So easements. Easements are servitudes, which are burdens on land and easements typically relate to access to property. In other videos, you can learn about the types of easements and about the ways we create easements. Just like there are specific ways to create easements, there are specific ways to terminate them. And that is the subject of today's video. So as you know from the other videos, one type of easement is an express easement, one that is set out in writing, one that satisfies the statute of frauds. Express easements often terminate by the terms of the easement. So you could have an easement that says that this is an easement in gross, remember, specific to a person. And it says that this particular person can have access to my property, can pass over my property for as long as she lives, but no one else after that. One example. Another example, if there's nothing in the express easement about termination, that implies that the easement is perpetual. So to terminate that kind of easement, that kind of express easement, one of the other methods that I'll be talking about today may have to be used. Okay, so moving on from express termination. Another way for an easement to be terminated is through a release. This is a written document that indicates that the beneficiary of an easement relinquishes the right to the easement. A property owner might seek a release from the beneficiary if they want to develop or build in the area of the easement. So she, the property owner, won't want for someone to have rights to walk over the very area that she wants to build in. In that case, the property owner might seek a release, and if they're smart, the easement holder might ask the property owner to compensate them for it. So what happens in a scenario when an easement is no longer used? Can an easement be terminated as abandoned? And the answer to that is yes. So this is yet another way to terminate an easement through abandonment. But you should know that the period of non-use has to be so long that it appears as if the easement holder has abandoned the easement altogether. So for example, if there is a railroad easement, you can show non-use by removing the tracks and showing it's not being used for railroad use anymore. Relatedly, an easement may be terminated if the purpose for which it was created is frustrated. If you have an easement, for example, so that you can walk over someone else's property to get to a common drinking well, but then the well is destroyed, then the easement will be extinguished for frustration of purpose. Here's another one, the list goes on. Just as easements can be created by prescription, they can be terminated by prescription, or better yet, by adverse possession. Both prescriptive easements and adverse possession are covered by other videos in this series. If the servient owner adversely possesses the easement, so here's our example, like blocking access to a road or to a pathway for the statutory period, then the easement will be deemed terminated. So if you are the servient owner, you may want to consider this if you're seeing that the easement holder isn't really using it, then you can reclaim that land for yourself. Similarly, just as easements can be created by estoppel, they can be terminated by estoppel. So what do we mean by this? So in this scenario, the easement holder is doing something that makes the owner of the servient estate believe that the easement owner has abandoned the easement holder, the person benefiting from the easement. If the servient estate owner relies on that behavior, and if allowing the easement would continue or create a harm, then the easement might be terminated for estoppel reasons. So finally, a couple last things. From a technical standpoint, there may be state laws that require the recording of an easement, putting a written record of the easement on the land records, no matter how it was created. These state laws, typically they're called marketable title acts, are covered in another video of this series. But for here, we just say that failure to record an easement might mean that you've lost your rights as an easement holder, and the easement will be deemed not to exist. So speaking of government action, what happens if government condemns property? So condemnation is covered in other videos as well. And it falls under it really means the use of eminent domain. Eminent domain is the power of government to take property as long as it is for public use and as long as government provides just compensation. Again, we cover each of these topics in other videos. For here, in the case of a condemnation of land subject to an easement, generally what will happen is the easement itself will be deemed terminated. Finally, an easement can be terminated through a merger. So a merger happens when the dominant and servient tenements, or the dominant and servient parcels or estates, are united as one parcel under one owner. If they are merged into one, then there's no need for an easement because you're not talking about benefited and burdened parcels or benefited and burdened parties. It's all one and the same. So I will leave it there. I would love to connect with you on Twitter or through my mailing list, and I will see you next time.